All right, Ms. Hunt, just so you know, normally I kind of give the defendant a little pregame on what we're going to do, and then I have you swear him in, okay?
Oh, okay.
All right. Oops. That's my live stream. Okay. Let's go ahead and be on the record in two cases, those being 2018 CR 17 and 2020 CR 24, both captioned State of Kansas versus Nathan Johnson. Would the parties announce their appearances, please?
May it please the court, the state appears by Assistant District Attorney Taylor Hines via Zoom.
May it please the court, Your Honor, the defendant appears in custody via Zoom with counsel Kyan Caprice also via Zoom.
All right. Mr. Johnson, we're going to go over your plea today, okay? To do that, I'm going to have to ask you a bunch of questions. I need you to answer out loud because the young lady, at least in my screen, she's right below you, is taking down everything we have to say. If I ask you something and I either get garbled or you don't understand what I'm asking, you tell me that, okay? So you and I can talk about it. Make sure that you're answering the question that I'm asking, all right?
Yes, sir.
All right. If at any time before you answer a question, you want to talk to Ms. Caprice in private, you just tell me that. I have the ability to send you guys to a separate room where you can talk in private, okay?
Yes, sir.
All right. And like I mentioned before we went on the record, I need to swear you in to ask all these questions. So if you'll raise your right hand, Ms. Hunt will swear you.
You solemnly swear the testimony you're about to give in the cause now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
All right. Mr. Johnson, how far did you go in school?
Ninth grade, and then I did my GED in prison, in Boonville Prison.
Okay. So you read and write okay?
Yes.
All right. I know you're in custody, but as you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what you're doing today?
No, sir.
Do you understand what you're charged with?
Yes.
And you know you don't have to change your plea from not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on those charges. You understand that?
Yes, sir.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. You know that?
Yes.
All right. Your attorney, Ms. Caprice, would be able to assist you throughout that trial. She would confront and cross-examine all the state's witnesses. She would challenge all their evidence. She could call any witnesses you wanted called. And if they didn't want to come to court, she could use the subpoena power of the court to make them come to court. You understand all that?
Yes.
At that trial, you would have a right to testify, but you'd also have a right not to testify, which means that you don't have to take the stand. And if you decided not to take the stand, the state couldn't use that against you. In other words, they couldn't get up and argue, well, Mr. Johnson must be guilty because he didn't tell you his side. You understand that?
Yes.
Finally, if we had that trial and there was a conviction, you would have to appeal that conviction to an appellate court. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes.
All right. Go forward with this plea today and you end up pleading guilty, you're going to be giving up all of those rights. There's not going to be a trial of any kind in this case. You understand that?
Yes.
All right. I'm going to share a screen here from computer. It went away. All right, 1 second.
Okay.
Can you see that document that I just pulled up?
Yes,
All right. We talked about it before we came on the record. Is this the plea petition? Yeah, and I'm sorry, I've been saying guilty, but you understand you're pleading no contest today. Is that correct?
yes,
All right. Is this the petition to enter a plea of no contest that Ms. Caprice sent you?
yes. And we also talked about maybe trying to get probation and having the backup. We talked about that the last time we had court.
We'll go through the terms of the plea agreement here. I just want to make sure that this is that document that you and Ms. Caprice shared.
Yeah,
All right. And it looks like there's a signature there where it says defendant. Is that your signature?
yes, sir.
Did you, when you went through this document, other than the Spanish translation that's contained in it, did you understand everything in the document?
Yes,
All right. Now it says here, as we talked about, the terms of the plea agreement, and it says this. It says that you're going to be pleading guilty, no contest to count 1, which is possession of methamphetamine, a severity level 5 drug felony, and count 2, felony theft, which is a severity level 9 non-person felony. The state's going to dismiss the other count. You all will agree to recommend to me concurrent sentences. That means that they'll be running at the same time and not one after the other. And that they will also jointly recommend a 6-month durational departure from the presumed sentence in count 1. That both you and the state are going to be able to argue disposition. In other words, you're both going to be able to argue whether or not you should get probation in this case, and then be stipulating to violation of the probation in the older case. Is that your understanding of the entire plea?
yes, sir.
All right. Has anybody promised you anything besides that to get you to plead guilty or no contest today?
No,
All right. Has anybody placed any force or threats against you to make you plead no contest today?
no, sir.
All right. Ms. Caprice, Ms. Hines, do you guys have an idea of what the defendant's criminal history may be?
Yes, Your Honor. We believe him to be an E.
I would
Is that-
agree with that.
Okay. All right. So I'm sure Ms. Caprice talked to you about the sentencing guidelines and where you might fall on those guidelines and what sentence you might expect. But you understand that until there's a pre-sentence investigation that everybody gets to see and make sure is correct, that states what your criminal history is, no one can guarantee that that's where you're going to fall on the sentencing grid. You understand that?
Yes,
Okay. Now, as to this case, what I have to do for today's hearing is assume that you have the very worst criminal history possible so that I can advise you what the maximum sentence that anybody can get for this crime is. Do you understand what I'm saying?
yeah,
Okay. So it's not here in the plea petition, but help me out. I believe in the severity level 5 drug felony, that is count 1, the maximum sentence is 2 months in prison and a fine of $100,000. Ms. Hines, do I have that correct?
Yes, you do, Your Honor.
Okay. And in count 2, he would be presumed to be an I. So the maximum sentence he could get on that, I believe on a severity level 9 is 12 months. Is that correct?
It's actually 7 months, Your Honor.
7 months for a maximum. Okay. So the maximum sentence for count 1 would be 42. The maximum sentence for count 2 would be 7. So total, that's a total of 49 months. Do you understand that that's the maximum prison sentence possible in this case?
yes,
Each of those charges would carry a maximum fine of $100,000 and a post-release supervision duration of 12 months. You understand that?
yes,
All right. Now I see in the plea petition, in the agreement, there's going to be some recommendations about what your sentence should be. And specifically that they run concurrently and that you get a 6-month downward departure. When we come back for sentencing, I'm going to listen very closely to what everybody has to say. And I'm going to give great weight to the recommendations of the lawyers. However, I'm not a party to those recommendations and I'm not bound by them. And I can give you any sentence that the law allows me to. Do you understand that?
Yes, sir.
All right. Mr. Johnson, do you have any questions about anything that you and I have gone over today?
No.
All right. And Ms. Caprice, do you know any legal reason why your client should not plead?
I do not, Judge. We've been working on this for some time, and I think this is in his best interest.
All right. Then I'm going to ask you, Mr. Johnson, as to count 1, the possession of methamphetamine, a severity level 5 drug felony, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. As to count 2, the charge of felony theft, a severity level 9 non-person felony, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. I'm going to ask Ms. Hines right now to tell me what she thinks the state's evidence would be if there was a trial in this case. I want you to listen closely because when she's done, I'm not going to ask you if you agree that that's what happened, but I'm going to ask you if you understand that that's what the state believes they could put on. Okay?
Yes, sir.
Ms. Hines.
Yes, Your Honor. If this case were to go to trial, the state would provide evidence that on January 6th of 2020, this year, Officer Xiong and Erickson with the Kansas City, Kansas Police Department were patrolling in the area of 55th Street and Parallel Parkway. They observed a Ford F-150 truck with a Kansas tag in that area. They later discovered from dispatch that that vehicle was actually reported as stolen out of Kansas City, Kansas. So they approached the vehicle and approached the defendant in this case and a female who were loading scrap metal into the back of that truck. Once officers Xiong and Erickson approached the defendant and the female, the defendant uttered, "I knew it was stolen because the screwdriver, but I borrowed it from a friend at Piper." And then he said he borrowed it from a person named Samantha that lives in an unknown location in Piper. And officers were trying to identify who the defendant was at this point, and were able to identify him as Nathan Johnson with his birth date, and then officers did a search incident to arrest of the defendant and found a small baggie with a crystal-like substance in his right front pants pocket that was tested the next day on January 7th with the TrueNarc drug identifier, and it tested positive for methamphetamine in the amount of 0.1 grams. After further investigation, Officer Xiong and Erickson were able to determine that the vehicle belonged to the owner of the vehicle was a Robin Charles Patterson, and that he did not give anyone permission to take the vehicle from his residence, and did not give the defendant permission to take the vehicle, and that the approximate value of the vehicle is around $1,500 because it's a 1993 Ford F-150. And this all occurred here in Wyandotte County, Kansas.
All right. Mr. Johnson, you hear what Ms. Hines had to say?
Yes, sir.
You understand that if we went to trial, that's what they think they could put on as evidence.
Yeah.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered into his no contest plea. He knows the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and I will in fact find the defendant is guilty of counts 1 and 2. Per the plea, count 3 will be dismissed. I'm going to order a pre-sentence investigation and continue this sentencing pending that. What I'm going to do for a sentencing date, folks, is I'm going to send you to Miss St. James because she didn't give me any proposed dates, and I'll have you schedule with her to set those. Mr. Johnson, as a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Okay?
Yeah,
All right, Ms. Caprice, you needed something?
Yes, Judge, before we end the Zoom, but can we go off of YouTube? I need to get his personal identifying information for the PSI
Right.
form.
Right, okay. Anything else that we need on the record today?
No.
No, Your Honor.
All right, then we're going to be adjourned. I'm going to stop the live stream.